Good morning. My name is Stuart Dresner. I'm Chief Executive of Privacy Laws and Business, and I'm here to launch our 24th Annual International Conference here at St John's College, Cambridge. Our theme today, this year, is how to align privacy with your business strategy. Many businesses depend on using and monetizing personal data. Even if you're not in the personal data business as such, many companies use loyalty cards and geolocation services, and so personal data is becoming increasingly an important part of how companies do business today. And the question and the issue is how to demonstrate that your privacy policies and procedures are accountable to your stakeholders. You want to derive commercial benefit from the data, but you wish to recognise there are legal constraints. You wish to show that you are a credible custodian of personal data, and if you have a problem, you fix it. So how do you assess the risk to your business strategy if your data is lost or stolen? Now, accountability is a concept which was in the OECD guidelines, which were launched in 1981. And so that principle has been there for 30 years. But in fact, the accountability principle has been mentioned very rarely since then, until the Accountability Project was launched by Martin Abrahams and Hunton and Williams' team about 3 years ago. And they have been exploring this concept since then, working with national authorities and a group of large companies. And the challenge is to look at to what extent this is a robust concept and does it stand up to scrutiny. So that's why our first session today is looking at that concept, looking at both the positive aspects, and we'll also give time to some criticism and some comments, negative comments, where the critics feel it doesn't, or consider it doesn't, is not robust enough as a system of a supplement to the system of law. Now, these are the things I'll be covering in my introductory talk, and so we can see there the importance of looking at accountability to different audiences, and we have several other issues there.
Well, first of all, if you wondered what that image was for, it's about finding the balance. And then it's about setting the right course. And for the ICO, we have to navigate between a number of competing force fields, directions. I'm mixing my metaphors, am I not? But the different points of the compass. First of all, you've got the ICO's statutory responsibilities. We are there to uphold the Data Protection Act, the Privacy and Electronic Communications Regulations, the Freedom of Information Act, the Environment Information Regulations, the INSPIRE Regulations, all this statutory stuff. And yet, on the other pole, there is, I've described it as public policy agendas. At the moment, from the government point of view, it's about transparency, accountability, open data. As we get further down the piece, we might find that governments have other priorities. New governments are always enthusiastic about openness and transparency because it's usually about the sins of the other lot. When you get a bit further down the parliament, history tells us that governments are not quite so enthusiastic. So the Information Commissioner's Office has to find the right relationship with our statutory responsibilities and the public policy agenda. We are enthusiastic, but we haven't got to be so enthusiastic that we get caught up in someone else's agenda. So that's on one axis. On the other axis, many of you will be concerned about the exciting possibilities of technology and all the new business applications. And your customers, your consumers, and the same is true for for the citizen as relating to public services will be interested but possibly a little bit alarmed about what's going on. Our research suggests that public concern about protecting their data is a very, very top priority. It's really up there with crime and terrorism. Something like 92% of those we surveyed in our annual track said they were very or fairly concerned about the security of their data. So what's the ICO's relationship in these various fields? We can either be a policeman or an enabler. Sometimes we're one, sometimes we're another. It depends on the issue. And in relation to technology and consumers, we are a facilitator and we're a friend. We're a hand holder, perhaps, to consumers. There's an important work for the ICO to do of education and guidance, both to service providers and to consumers. And the Linklaters question yesterday, educator or enforcer? Well, the answer probably is both.
Why are we having this review? First, I would say that the most important part of the framework, and that is certainly the directive, is showing its age. I've recently mentioned we're approaching the end of consumption date. And that's true. It's likely to stay as is for a number of years, but we cannot afford to make this much longer. And part of the problem is also that we see now increasing diversity and complexity developing within the scope of the directive. That was the plan from the beginning, but of course all these national transpositions, which sometimes are contradictory at a horizontal perspective, are not helpful, and there is increasing complexity, and the challenges are increasing. So we need to scale up to the reality, global, increasingly technologically driven internet, etc. Now, the second is the impact of the Lisbon Treaty. Now, this may be far from your reality, but it is a reality for all member states, and it is dynamizing the environment of the discussion. And one of the elements is the strong emphasis in the treaty on fundamental rights and the introduction of a new legal base for data protection has driven a more comprehensive, a more horizontal approach. So there is more now thinking, how should we do this well, and not only to make the internal market work better. And then there is an important driver in the digital agenda, already mentioned, and the longer perspective of the EU 2020 strategy, where the key words are smart, sustainable, and inclusive. And you understand the sentiments behind this. But we can never do this really smart, sustainable, and inclusive if we do not include data protection from the very beginning. And this is why it is such a critical success factor for many other policies which are building on this. So this is why we have this review, and this is quite obvious. This, in spite of the Swiss ban on slides, Chris, this text is important, and I have underlined some elements. This is Article 8 of the Charter, which is not part of the Lisbon Treaty, but there is one article making it binding nevertheless, the entire Charter. And it is the summary, the constitutional law on data protection for the European Union. So it states the right to protection of personal data. It sums up the key messages, and there is a strong emphasis on independent authority. You see that with a reference to the case, which explains what independence means. Now, the attention to the first line, because this is then echoed in the Treaty on the Functioning of the European Union. This is a new name for the EC Treaty. And in the EC Treaty, you find Article 16, That's quite prominent among the general principles of the Union, where this is translated into an obligation of Council and Parliament acting in the ordinary legislative procedure, which means the usual co-decision rules, qualified majorities in both houses, but co-deciding, to lay down rules relating to the protection of personal data by the Union institutions, but also by the member states when carrying out activities within the scope of Union law. Actually, this is now the legal base on which the review will be done. And it's not, I'll come back to that, it's not about making the internal market work better, but it is about data protection proper, rules on data protection. It doesn't say directive, it doesn't say a regulation, it simply says rules. And it is going to cover data protection at the European level, at the national level, within the scope of EU law. Of course, not everything. It could not be outside the scope of the treaty, but that is still a very big area. So I want to make you aware, and this will then have to deliver, in any case, what the Charter requires.
Well, definitely we start from the digital agenda and what's said in the digital agenda, since we see that this part of the work seems to be the most important for the common market. And Poland, as you probably know, is still quite enthusiastic about the idea of the common market and also in the electronic form. So for this reason we support all the actions that will create the single market in Europe in the electronic field, and we understand, as it is said in the digital agenda, that it is not possible to reach such a situation without the confidence and trust among the society in how it operates and how secure it is. So to take the measures which are shown in the digital agenda is the condition sine qua non for the single market. So that's, I may say, the priority. Of course, we were expecting, even half a year ago, we were expecting that we will start to work on the new legal base for the personal data protection in Europe. As you know, the Commission said that the draft will be ready by June. Even if we didn't expect it in June, we thought we will start the discussion around September. It will not happen. As you know, the date which is right now given by the Commission is late November. So it means that the work actually will start in December, right before the Christmas time. So we do not expect anything else as far as the legal background is concerned than just the kick-off of the discussion. And we would like to do it during the Polish presidency to show that this is the very important aspect of the activity. That's also connected with the fact that we were not taking part in preparing the background that we have right now. As you know, Poland is the member of the European Union since 2004, which means that we somehow inherited what the other countries decided some years ago. Our law on personal data protection is already from 1997, but it was based on the directive, but we didn't have any role in preparing the background, the legal background that we have at the moment. So for this reason, it seems to be extremely important for us to prepare the background for our future work.
So before launching into the case study, I just thought it would be useful to briefly talk about the overall IMS data protection compliance programme so that you can you can sort of think about this when I'm talking about the case study. This is the context in which this case study is being run. So we have a network of data protection point of contact in each European country. These are the people on the ground that will tell us when issues are coming up. If they've got problems, they'll know to come to me or to Barbara. And they are the local people that will liaise with the local council if that is required on a project. We are going to be rolling that out on a more global basis very shortly. So the idea being that across the whole global IMS, we will have a data protection point of contact within the business, embedded within the business, within each of our geographical locations. We have a very well-established data protection audit methodology, and those of you who know my colleague David Trower, and I don't think David's in the audience at the moment, but David did a lot of work on developing this audit methodology, and it's something that we've kept going and we've grown and enhanced upon it, and we choose a few IMS entities each year within Europe, and we carry out data protection audits in relation to those entities. We have binding corporate rules. Now, many people may not know that IMS has binding corporate rules. It's not something that we've publicised to a great extent, but we did receive our binding corporate rules approval back in May of last year. We have mandatory data protection training. So this is training that's online. It's required to be undertaken by all new starters to the organisation, not just employees, also contractors. And I think that's quite important because contractors often do form quite a large part of the people who are accessing your data, and it is important to make sure that when you are applying training, you're not missing out a whole chunk of people who may also be having access to your very important data sets. So this training has to be completed within a certain amount of time of the individuals joining the organisation, and a certain score has to be reached in order for the person to have successfully passed that training.